Welcome to Cebsar-Talk. I am Evans Apia Kisi, the host of Cebsar-Talk. Cebsar is Center for Better Society Advocacy and Research Africa. Cebsar Africa is a non-profit organization that believes in a better society for all. We in Cebsar Africa believe that a better society begins with you and I. Hashtag, a better society begins with me. For more information, please log on to www.cebsarafrica.org. Please follow us on the various social media platforms: YouTube, Cebsar-Talk, Facebook at Cebsar Africa, Instagram, Cebsar Africa, Twitter at Cebsar Africa. Like always, today we bring you another interesting discussion on the topic or the ongoing Ghana's election petition 2020. And Ghana went into its 8th elections in the 4th Republic on the 7th of December 2020. Although the elections were generally hailed as successful, others believe the December 2020 elections were not flawless. The Electoral Commission of Ghana declared the winner of the elections in favor of the New Patriotic Party, but the opposition political party, the National Democratic Congress, was not convinced the results of the elections were credible. This led to many press conferences, protests, and demonstrations, especially from the opposition party. Finally, the flag bearer of the National Democratic Congress, Mr. John Dramani Mahama, petitioned the Supreme Court of Ghana to challenge the validity of the declaration of Mr. Akufo-Addo as the winner of the elections. In this episode of Cebsar-Talk, we educate our audience on the law and what's happening in the ongoing election petition at the Supreme Court of Ghana. And to help us deal with this important issue are Mrs. Akosua Jima. She's one of our regular panelists here. She's currently a doctoral researcher at the Lancaster University School of Law, UK. She holds Master of Social Work at Carleton University, Canada, MA in Human Geography and Resource Development at the Western University, London, Canada. She also holds LLM in Diplomacy and International Law from the Lancaster University, England, BA in Human and Resource Development at the University of Ghana, Ghana. Her expertise lies in foreign policy, social policy, international relations, geopolitics, human rights, and international law. Like always, I must say it's a pleasure to host you. Welcome once again to Cebsar-Talk, Mrs. Akosua Jima.
Thank you very much, Evans, and thank you all listeners. I'm happy to be back.
Great, thank you very much. And our next guest, who is not yet here, but I'm sure will join us very soon, is Mr. Said Abdul Hafiz. He's currently a law student at the Ghana School of Law. As and when he comes in, we would give him a formal introduction to it. Great. So, Akosua, thank you very much for your time. And then I must also say that to our fellow, I call them our fellow Cebsarians who follow this program. It's been aired live on Facebook, on AKMS's wall. I have also shared it on my wall, and on the those of you who also follow Cebsar Africa, do spend time with us the next 60 minutes, and I can assure you that you would learn something about the law, particularly as far as Ghana's election petition 2020 is concerned. So thank you very much, Akosua. So quickly, maybe I should ask you your your impression so far. I mean, what's your take as far as this Ghana's election petition is concerned? I mean, just briefly, what maybe what is election petition? Of course, in the background, we have given what necessitated this election petition. But briefly, from your side, what's your take on this election petition and election petitions generally?
I mean, as I would say it again, and I've said it before, my area of law is in mostly in international law and European law. And so Guinean laws per se, I follow what is going on. So that is really not my expertise.
If you, sorry to come in, if you could just stop sharing your screen, I'm sure the appropriate time would allow.
Oh, sorry.
Yeah, thank you.
Sorry.
Great, that's fine.
Sorry, my hands were clicking stuff. But anyway, what was I going to say? I was going to say that Guinean law area is not my expertise. However, as a Guinean, from a Guinean, have part-time Guinean, whatever anybody would call ourselves, I've been following things that are going on. What are my impressions of it? I think the law permits that, and as we may see later, the Constitution, I believe Article 64, Clause 1, I believe subsection 1, states that any Guinean citizen can challenge the election if they have reasonable grounds, and it sort of specifies grounds under which you may challenge the results of the election. So I think that is within anybody's right. However, as we may go into details, it specifies you just can't get up and say, I'm going to challenge it, because they don't really provide a threshold, then everybody else will be getting up. If they disagree with somebody, to be challenging, and I don't think it would be sustainable. So what do I think? I think it is provided that people can. They also provide the circumstances under which somebody can challenge it, and then how they should go about it. So Mr. Mahama did obviously had a problem with the results and wanted to challenge it. So I guess we're all looking at what evidence is there and whether that is convincing enough and whether that meets the threshold to be able to win that case. So I'm not so sure whether I answered your question, because again, there is more detail. So I don't know how much detail to give or how much I should sort of stop. So.
No, it's fine. I mean, you made very fundamental points that there should be some kind of threshold, and it's not as if the law provides for it, so anybody at all could, stand up or wake up and say that I'm filing for an election petition. But just briefly, so who is eligible to file for an election petition? If I did not partake in the elections, could I file for an election petition? And what kind of threshold is required for one to be able to file for the election petition?
So give me 1 second, because I don't want to make it up. I want to state exactly what the Constitution says.
Very well.
As to the circumstances under which or who qualifies. So I will say that so people know who can challenge it. I think that this is provided under, as I mentioned, give me 1 second. Essentially, the Constitution says somebody who has, so the relevant laws that provide for that is, as I said, is the Constitution that says section Article 64, section 1, which I was gonna just read exactly what it says so that people know. But essentially, a citizen of Ghana, if you're not a citizen of Ghana, you could not. All right. So if you are a citizen, that's when you can challenge an election, a presidential election. And here's what it says, Article 64, and it's titled "Challenge an Election of a President." And this subsection 1 says the validity of the election of the president may be challenged only by a citizen of Ghana who may present a petition for the purpose to the Supreme Court within 21 days after the declaration of the results of the election in respect of which the petition is presented. So essentially, any Guinean citizen can challenge it, but then they have to bring the petition within 21 days after the electoral commissioner has declared the result, and bring their petition. And the petition, as you go along, there are different rules that specify as to what you should bring to file a petition before the Supreme Court. So just to answer your question, the Guinean citizen can't do that.
All right, very well. And maybe quickly, I should also ask that, of course, this is not the first time we are witnessing an election petition. Perhaps, I'm not too sure, but I think this would be the second one as far as the Fourth Republic is concerned.
Mm-hmm.
And just wanted to ask, do you find any differences? I mean, I'm sure we'll come to a few of the details of what is going on and the various terminologies that are being thrown out as far as the law is concerned. But do you find any differences, as far as the election petition 2012-2013, vis-a-vis this current election petition? Are there any differences, or they are pretty much the same?
There are differences in the substance, right? So essentially the reasons for which the other party went for the challenge, the specific facts are different in this case than those cases, right? Because if you would permit me, the previous one, first of all, I think they probably changed the rules a bit, because the previous one, Mr. Kufuor plus Mr. Bawumia plus Mr. Obechebi-Lamte were the petitioners. So each one of them filed their own challenge. So they were on one side, and then Mr. Mahama, and then the Electoral Commissioner, and the NDC were the respondents. So even the respondent, in terms of the nature of it, you could see a little bit of a difference. Now it sounds to me they changed it. So as I was hearing from those who know more about the Guinean law, it sounds to me the person, now they change it to the extent that the person who is offended, who is bringing it, can file the petition. In this particular case, Mr. Mahama is the one who has a problem. So he is, and he alone is the petitioner, right? Then he has to support it. He has his party and his legal team supporting him. So that's one difference. The other case, as I said, there were three people. The candidate, the vice presidential candidate, which was Mr. Bawumia, as well as Mr. Obechebi-Lamte, probably standing for the NPP. Exactly. They were all filing their petitions, okay? And then they also sued the NDC alongside the Electoral Commissioner and Mr. Mahama, right? So you can see the difference there. In terms of the substance, those days, the issues they brought before the courts were, one of them was overvoting. They alleged that they were overvoting. They also alleged that the Electoral Commissioner had allowed voting without a biometric verification in some places. And they had a list of places. I believe they outlined there was a big number, like many areas where they claimed that the Electoral Commissioner did not make people vote, like didn't verify their identification by biometric verification. And then the third reason was absence of the signature of the Electoral Commissioner or the presiding officer on their vote counted, which the law actually mandates the Electoral Commissioner to deal with. And then they also alert, the fourth reason was they said that some of the results on the so-called pink sheets, there were different serial numbers on them. So for example, the same said then there were different serial numbers producing different results. And then they had a fifth reason, which was they said that there were duplicate station codes, because apparently each of the polling stations has a code. So then they saw that one polling station will have different code assigned. So that means they thought some codes were fictitious, right? They were unexplained. So they were sort of, and then the sixth reason was they said there were some polling stations that were not on the recognized polling stations. So again, they thought that was manufactured. And then they said, at that time, Ghana had 26,000 polling stations. However, they found a couple of them that were not on it that also people had voted. So they challenged them on these grounds. This time, as we all hear, it's about the quote unquote, the error. They claim multiple numbers were announced. And so they feel the credibility is not the results were not credible, and so electoral commissioner had apparently produced too many numbers and made mistakes, and we all been hearing the reasons. So that one I didn't go too much into details, as that one is more obvious.
Thank you very much. So pretty much a bit of differences here regarding the number of petitioners. I mean those who were also sued, and then substance, I mean the issues that were dealt with. These are the main differences.
Yes.
But you said something, and also that adds to a question that has been posted to me already, that, and so in terms of the citizens, because you said the Constitution allows a Ghanaian citizen to, file for this election petition. But I think in trying to draw the distinction between the current election petition and that of 2012, 2013, I think you drew some distinction that now it appears it's the petitioner who is allowed to present the petition. But with regard to a Ghanaian citizen, should it necessarily be one who is part of the opposition party, or it does not matter the party that you belong to? And how do you differentiate that with now the new rule or law that says that the one who is affected, the aggrieved person, should be the petitioner himself or herself?
That part, sadly, I didn't get time to go into it, but I also recognize that after the 2012 ruling, 2012, 2013, I believe that necessitated, because one thing was, I would say a few things. The court at that time ruled, and the electoral commissioner agreed that they made many mistakes. Okay, so some of, even though the court threw away certain things, the reason they threw them away, they threw some of their facts, and again, if I were to look on it, because again, I don't want to misstep, but they threw 3 of the reasons away on the basis of the fact that they didn't think that if they included it, it was going to make a difference in the result. The 3 main ones on which they ruled was the lack of signature by the electoral commissioner, their so-called duplication of stations, like the code issue. And then I think, was it the overvoting or some sort of, so they had 3 main reasons. They took 3 main factors: duplication of their station, I believe, and then their code issue, plus the electoral commissioner not signing. And I believe at least 905 of the pink sheets they didn't sign. The electoral commissioner did not challenge that argument. They agreed that that was true. The court also knew that the law says it could have been invalidated. Okay, the reason they did not invalidate and they ruled in the president at the time, Mr. Mohammed's favor, was they looked at the purpose of the Constitution. What they call the object and purpose, or the framers, or the intentions of the framers. So they try to not use their test, because normally when they're interpreting the law, there is the actual test, and they're supposed to look at the test and interpret it based on the test and not add anything, right? However, many times, or increasingly, what judges are doing is to go back, because the world is changing so much. Oftentimes they go back. In the UN, for example, they go to what they call travaux préparatoires. Travaux préparatoires is when they're developing the laws, normally they spend a lot of time going back and forth. So almost like the scribbled notes, that's the travaux préparatoires. So normally they have all the details in there that explain, for example, if they said Article 64, they would detail how they came about with the test. So increasingly with the last one, what the judges did was they decided to look at the intentions of the framers of the Constitution, and what they extrapolated from it was the intention was to respect the voters' votes. So therefore, they did not want to invalidate it because the electoral commissioner made a mistake. They wanted to respect the vote of the people because it is their fundamental right. So after that, they made different rules, and I'm not so sure why they made rules to specify. So the details of it, unfortunately, I haven't read it. However, they have a CI 74 and the Public Elections Act, and they have, I didn't get time to go through all of it, but they have detailed all the rules and regulations in there. And I'm also hearing C99, I believe that came about after the last election. And I do believe they would have specified why they made those changes, and as to who now qualifies should be in there. But as we can also go through Rule 68, Rule 69, it also specifies certain rules around there. So it's a little complicated. So back to your the listener's question. Unfortunately, I will not be able to, I mean, perhaps we may have to develop another time or devote another time to get to that one, but I will not be able to answer as to who can or what anybody. But what I was hearing the Guinean lawyers say was this time, it is only the petitioner who can, not many other people, as the first case. Without looking at the fact or without looking at any test, my speculation might be because the other one, I think it took too long. It took about 8 months. And as you can see that this time they're talking about 42 days, 42 days. So I think the intention was, because if you're going to challenge it, let's say if they challenge it and then the Supreme Court ruled to have Mr. Mahama or to have a rerun and Mr. Nana Akufo-Addo has to be deposed, for example, 8 months into their presidency, it becomes difficult because by that time they appointed so many things. And if you go to the 64 clause number 2, it says that when the Supreme Court rules and they rule to, let's say, declare the other one as invalid, the result as invalid, and bringing in a different president, the previous thing that Mr. Nana Akufo-Addo had done before the ruling, nobody can hold anything against him. He would have done it and done it. So now I suspect probably they did that in order not to drag it on for a long time. So then if they're going to be overturning it, it better be done quickly so then things don't go too far. That's my suspicion. That one is just from my opinion, but I don't know for fact why and who does.
All right, thank you very much. So, I mean, this might sound a bit funny, but there are people who would ask it as it is. I mean, was there really a need for this election petition? Or maybe let me put it this way. You speak to some friends and they're like, well, maybe they shouldn't have, or there's no need for this election petition. They should just accept it and move on. I mean, regardless of whether people have confidence or not in the court, generally, do you think, election petitions are necessary? Are they important at all?
It would be inappropriate for me to say he shouldn't have, because it is his constitutional right to do so. Do I advise him? I'm not his advisor. His advisor should have looked at the merit of it, see the previous ruling, because if you even look at the reasoning for the previous ruling, it wasn't so much that they didn't have the facts, but it was so much, as I said, most of the interpretation was based on could that have made a difference, all the mistakes, all the so-called irregularities, because in fact, in the conclusion of the court, they made a statement to say there were a lot of mistakes and irregularities. However, they went back to the intentions of the framers of the Constitution, and then they also mentioned Ghana has voluntarily opted for democracy, and by doing so, they wanted to respect people's votes. And therefore, to base their ruling and disenfranchise the voters on the basis of the mistakes by an official in this case, electoral commissioner and his agents, they did not think it was worth it. So if you look at the details, and then the other reason, as I said, was they kept on coming back to, if we put all these mistakes together, would that make a difference in the result? Would that have made a difference in the outcome? So it hinged on these things, right? And the two reasons. So if I were to advise him, probably now I don't want to say anything because they haven't ruled, but it is his constitutional right. Sometimes people don't go to court because they necessarily want to win. Sometimes they want to make a case. Sometimes they want it for the record. Sometimes they want it for people to see. They want to tell a story, right? So people have different motivations. So I don't know Mr. Mohammed's motivation. Maybe he wants to win and overturn it, but it may not be so. It may just be that he feels aggrieved and he feels it has to be for the record. Some people want their names in the record, right? So I don't know his motivations. His lawyers, he would have confided in them so they will know. So for me to say it's not necessary, I think that it would be totally inappropriate, and the law permits him to do it, because if it didn't permit him, the court would have thrown it away to say, I mean, it has no merit or it's not. But because it is his right, he has to go through the process. And sometimes when you go through the process, it's a civil case, sometimes people seek remedies, sometimes people seek compensations, people would seek what is called justice. So it may not necessarily be overturning, that would be the outcome, but it might also result in some reforms in the electoral system. So yeah, the reasons could be varied.
Great, so thank you very much. And so I think that was a very brilliant answer there. For those of you who keep on wondering why, you know, this elections have been dragged to court, that's it. One is his constitutional right, as it's been said here, and perhaps also we might, you know, have some electoral reforms from the election petition. So Akusia, thank you very much. And those of you who are joining us, this is Cebsar-Talk, and today we are having a discussion on Ghana's election petition 2020. And do let your questions and comments come in. Great. So I actually wanted us to move this way. We know the case is ongoing. It's getting interesting day by day. And so far we've been, should I say, we've been bombarded with a number of constitutional terms, a number of law terminologies. And we would want viewers and our followers to be able to understand some of these terminologies. At least one of them, which I would say became popular in the last 2 weeks, was the issue of the interrogatories. The interrogatories. What are they? These interrogatories, what are they? If you could walk us through some of these terminologies that have been used so far. We also hear of case management. We hear of evidence and witnesses. Cross-examinations, I guess, is not new because of what happened in the previous election petition. And then recently, we hear of the subpoena. And I think we would be happy if you could walk us through some of these terminologies. And if you want to share some screen, you can go ahead and do that as well, to educate us what these terminologies mean in law.
But interrogatories, I think that it comes from like interrogating somebody, right? So it's like almost asking questions. So that's sort of where you're interrogating somebody. I think a lot of times, am I doing it right? I hope so. So essentially, that's what it means. I could go through, you mentioned interrogatories. So interrogatories are the questions that a lawyer would be questioning the other person. And typically, have you seen the screen? Oh, it's still ongoing.
Yes, we've seen it. If you could switch to
kind of display mode or whatever that is.
Exactly, to put it to slideshow.
I hope I've done it. Have I done it?
No, I think it should be at the, yes, fantastic. So go ahead, please.
Okay.
So you could start with the terminologies that have been used so far, the affidavit and
Okay, so there, as you can see there, so affidavit, it's because again, I know that they were going back and forth. Somebody wrote an affidavit. So affidavit is a written statement made officially under oath, right? Under oath and under affirmative, just to promise the court that you're going to be testifying, for example, or you're going to be saying something, you're promising to say something before the courts. So as you could see, electoral commissioner, I don't know whether your questions will come back later about witnesses testify versus not testify, but the thing is, affidavit, you sort of a statement that you swore to say this statement is true and this and that and that. So that is affidavit, right? So it's a written statement made officially under oath or affirmation, promising officially that you will be telling the truth as evidence before the courts, right? And then you mentioned interrogatories. So it's a set of written questions that are formally put to the other person. For example, Mr. Chikata would be asking a set of questions for Mrs. Jean to answer. So those questions during litigations, they may ask those questions to say you may be responding to these questions. Those are the interrogatories, right? So those are just questions. And I think that sometimes they use these big terms, but I think part of it is because in the past they used to use Latin words. And second, I think because of the legal profession, I think it's almost like a medical profession. Sometimes using jargons probably make them look powerful. I think it's all political, I guess. I shouldn't be saying this maybe. And so hopefully I answered that. I didn't know whether you want me to talk about the interlocutory orders.
That's fine. You can go ahead, please.
So interlocutory too, the judges order something. As you could see before they started, the judge could, for example, say, file your statements, right? Or they should do this. So the orders that the judge would be issuing would be their interlocutories, right? We would issue and say, bring this, do that. And so the judge's orders or decrees during, in between or prior to a litigation will be the interlocutory. So those are orders issued by the judge. And then, so essentially the interlocutories are not final, right? So sometimes they are not, because they are not final, they are not subject to appeal. So the judge is telling you to do this because again, the proceeding is gonna start. So they issue that order, either to do this or not to do this. And normally you see that they give them a timeline to do this and bring forward that kind of thing. And in Ghana, a registrar includes a judiciary secretary as well as the deputy judicial secretary as well.
All right.
And I think AK had mentioned petitioner. The petitioner is, it's obvious, somebody who brings a complaint before the court that they've been aggrieved, right? So it could be a civil case or a criminal case. In this particular case, what we're looking at is a civil case. So just because nobody committed any crime against the state. So, not so much to kill somebody or steal anything, it's more civil. And then case management. Case management is a system that is designed to reduce unnecessary delays and cost. Because as you could see it, sometimes some issues can drag on, and we started by talking about the fact that the court or after the other ruling, they started to make changes so it doesn't drag on, because court cases are very expensive, not only to the lawyers or the litigants, but they're very expensive to the states as well, because the judges, they're sitting, their resources are all paid by the state. So they're very, very expensive. Prosecution, very expensive. So normally they don't want it to go on and on. Actually, in the European system, if you bring a case that in the end, it didn't have a substance, sometimes they make you pay, whoever loses, they make you pay the expenses of the other one, just to prevent people from abusing the court system, right? So you don't, so that comes back to your question around how anybody else can get up and go to the court. So the European system, if you bring a case knowingly that it's frivolous, or if it's an abuse of the system, if you lose, sometimes they make you pay the expenses, some of the expenses, especially of your other party. Every expense they did, they're gonna make you pay for it in the European system. So again, the case management is designed to reduce some of these unnecessary designs. So in this particular case, as we can see, sometimes the court or the judges will actually strike out some of their information they are bringing. For example, if they see that it's irrelevant, it's gonna make a huge difference, or it doesn't have too much substance, you could see that sometimes they strike out 4 of them, because again, they don't wanna waste time and resources spending on something that they didn't think you couldn't support or couldn't make a difference on the case. So, or if somebody already admitted, for example, if I brought something against you and then you admitted that, yes, Apusia, I accept that, I did that wrong, there's no point bringing it in to waste time on it. You already sort of accepted responsibility. So case management is to sort of streamline the case so then unnecessary delays are trimmed to reduce cost, and also, I believe, to improve efficiency. And typically they sort of, they're meant to fasten the process. So that is case management, just so they can focus on the main issues that are relevant for ruling. Unless you have, and then you bring about a subpoena, that was the last one.
Exactly.
So as obvious, it is a writ that is issued by a government agency, most often a court, to compel a testimony by a witness, right? So again, just to produce evidence. And as we can see the sequence of things, I think the petitioner's lawyers wanted the Electoral Commission to come and testify. And then the judges ruled that they cannot compel her to testify. And then again, they cited many reasons why. They said it is not supported by Guinean law and by common law, and they do scour through every law, and it is not proper. And they also cited general principles. Essentially, they're saying by law, you really can't force somebody to testify if they don't want to. And so now it sounds to me that the subpoena issue is what the petitioner wants to use to force the Electoral Commissioner to testify. But essentially, the judges have gone through just to explain why they don't think they have the power, or it's appropriate, or it's lawful for them to force the Electoral Commissioner to testify.
Great. Thank you very much for walking us through these terminologies. And yeah, maybe we continue from there. Perhaps we might later share the other terminologies. Because of time, I wanted to follow up with some few questions. So if you could stop. Or we could also go on if there are other important things. If you have just 1 or 2 more slides, then let's.
What I have is not really the jargons. It's more around perhaps other questions of relevance and stuff like that. But I don't need to. You can focus on your questions.
Exactly. Then let's.
This is gonna distract you.
Sure. Then let's drop that with the great. So thank you very much. And maybe I should start off from where you ended with the subpoena, which the lead counsel for the petitioner, seeks to use. But what's your thought? I mean, yes, the judges have spoken that the EC chairperson cannot be forced or cannot be compelled to mount the witness box. I mean, this is law, but what's your take on people who also feel that perhaps maybe is it not a form of accountability? Don't you think she should have not necessarily been compelled though, but at least to mount the witness box to clear the minds of other people so that it helps to, promote or, improve accountability of our electoral commission? We gave you an assignment to do and want to find out from you how well you executed it. beyond the law. What's your take on that? What's your take? What do you think those who hold that position?
My take is in every country we have different institutions for different reasons, right? In between courts and if you have a dispute, there are so many ways of resolving it. Courts have a specific role. So if you go to court, you want a specific something. You can't go to court and just because maybe things didn't work your way, try and make the court do something else for you. Okay, so if you really wanted accountability, it is not just the court where they seek accountability. Okay, when something happens, the UN has steps of resolving conflict that every country really, it's kind of a normal process. I would say it's a kind of a general principle. When you have a litigation or you have a dispute with somebody, they have listed, you start with negotiation. For example, an inquest could have brought about the truth or whatever you want to know. An inquest could bring about it. You could negotiate. An audit could bring about this information. But if you go to court, you go to court for a specific reason. They went to court for a specific reason, and the courts have powers because normally each of the government institutions are mandated for a specific thing. So their roles are prescribed, right? So you can't go there and make them do something else you want just because that's what you want, okay? The court, their role is to apply the law and interpret the law. So you went there with a specific reason, that is their motive. You can't go there and divert because this one doesn't work. So you turn to that one that say, what about this? You don't do that, right? So, but I think that, I mean, my opinion is they wanna, as a petitioner, they wanna explore everything. They wanna capitalize on everything. But the judges also have to rule because they cannot have powers. Normally, powers are what is called conferred on them. In other words, they cannot go beyond the powers that the Constitution has given them. And so they said the Constitution does not allow them to compel. Okay, fine. Every individual also, so now you're talking about, okay, if they cannot compel, then maybe the electoral commissioner voluntarily should mount their box or whatever that is. The same Constitution that gives the petitioner the right not to also testify and be in there, the law is no less for the electoral commissioner than the petitioner. You understand? So that was one of the challenges they did because they said because he's their state agent who is appointed constitutional body, that even mandated him the point you just made for accountability. But the judge just asked the lawyer, Mr. Chikata, to cite a law that support that. He could not bring any law that support that. And when they also looked, they did not find any. In fact, they cited about almost 10 cases of previous rulings whereby each of the judges, including Supreme Court cases, and some of them across the world, decided some Canadian cases, Uganda, whereby in nowhere in anywhere else where a court can force somebody who changed their mind. And then they made the argument that he made a statement. One of the concerns the court had was the reason you cannot compel the person until Mrs. Jean testifies, the statement, the information in the affidavit cannot be used against her because she hasn't sworn on it in the box. Once she does that, if she commits any mistake, that can be held against her to suffer. And she alone will suffer the consequences should she make any mistake. Her lawyers have advised her to stay away. They already made a case based on what they presented to stay away. So then she comes in, she suffers for it. I mean, I don't know whether but they just feel that, you know what they have enough. So therefore they're not going to. So for her own sake, she decided not to. So I don't know whether people are saying for the nation's sake and for whoever. I think the judges looked at it and they didn't think the rest of the population have more right than she does. And they also didn't see in the Constitution that because she's a constitutional body, there are different rules that apply to her than everybody else. And they also said, just as the 5 witnesses were supposed to come and 2 decided not to, they did not compel them to bring the 2. So again, they did not, you cannot apply different rules to different people. They did not say you need to compel your 2 other witnesses to come. They just let it go. The same rules they feel apply to everybody. I do feel, I don't know what powers Parliament has, but in my general experience, I would like to think that there are different mechanisms for holding the Electoral Commissioner accountable. And they did not use those avenues. They could still explore those avenues because we have Electoral Commission Act, which should specify the circumstances under which Electoral Commissioner, if they didn't do their job well, what you should apply. And to me, that's what they should look at. And there may be so many other ways of getting the quote unquote the truth, rather than in this particular forum, the judges said they are restricted and they cannot do any more than what the law permits, and the law does not permit, and she voluntarily elected not to. So then that's where things are, in my opinion, and reading their judgment, that's what I extrapolated from.
Thank you very much. That's a very comprehensive answer there. But, and so I'm a bit worried. I don't know whether I should ask my next question, because I get the sense that it might be the same way that, well, the judges also have, their powers are also limited. It's not as if, and they have a specific mandate. But some also, you know, were, should I say, held a different view that in the case of the petitioner wanting to verify, you know, some of the official documents of the EC, this we know was also struck out, and people feel that, is it not their right to information? I mean, we've been preaching about the right to information bill that has recently been passed. At least, what do you also say to that? I mean, yes, probably the court still has a specific mandate that they have to deal with, but sometimes shouldn't some of these things be granted so that at least it helps to settle some dust?
I think in Ghana, we convolute everything. The reason being, every step, the Constitution specifies how we should go about it. Even the right to information, I think certain informations are still classified. In this particular case, though, they're litigating. It's not like they finished, Electoral Commissioner published it, it is there, anybody can go and say it. In this particular case, they are litigating. So they are adversaries, right? So then I have my information. I think that the information that the judges need to rule, that one they can compel each one of them to bring it for them to rule, because they're the people that will rule on the case, right? But if they also have enough and they don't think it's necessary for them, they cannot compel the other. I get it with you saying that they should get that information. Is that for public purposes, or is that for them to win their case? In this particular case, there's a specific purpose though. The purpose is to help them win their case, right? It's not like it's for public. The information, for example, Electoral Commissioner, let's say the whole case is done, and the general public, like you are a researcher, or a general public wants the right to information. I do believe the right information bill, or now it's a law, I think, would specify what kind of information the public should access, the processes through which you can access that information, right? So again, you don't go to court and litigate, and through there, it's almost like you're using the backdoor approach to get some information. There is different processes for different things. And the Constitution normally would specify what information and how you could access it. So in this particular case, I'm not the expert of the Guinean processes, but in my general experience, I would like to say that in this particular case, they are litigating. It's like you and I are opponents. We are competing for company, and you're like, tell me your ingredients for making this. I can say, no, I'm not telling you. But if the government wants it, so to make sure that I'm following proper standard, the government may force me to give it to them, but you may come to me and I will not give it to you because you are not a government, right? You, in this particular case, Mr. Mahama is a private citizen. He's a former president, but he's only covered by being a former president, having certain privileges as a former president, but he's a private citizen. So you cannot force a public agent just for your own sake. But if the whole public wants something, I think that at that point, it has to be looked at. And if there are no laws to do that, then Parliament may have to do new laws to allow more transparency in the way they want it. That's my opinion in this particular case. I mean, I don't know whether I make sense at all, but
yeah,
that's
sure.
what I think.
Thank you very much. Maybe I should read one message from Edusei, who says that, I mean, I think it's in reference to a question I asked about whether the petition was necessary or not. The petition, in my opinion, is necessary in that it's a way of ensuring that the democratic process is strengthened. In some jurisdictions, the disagreement would have simply resulted in violence, instability, and outright war. Therefore, resolving electoral disputes through the courts is an important way of avoiding conflict, insecurity, and instability that we often witness in Africa. It's up to the court to do its work without pressure from anyone. Again, but I mean, as a matter of concern and as an advocacy group where we also try to understand some of these things, I still would ask, also with the third witness, I mean, of the NDC, which also resulted in a lot of hilarious moments, I would say, with issues around tea and biscuit. But before that, we know that the witness had about, 32 witness statements, and 5 of them, as it were, was struck out. What's your opinion on that? I mean, people also again feel that they could have allowed him, all these 32 statements. What's your opinion on that also?
I mean, I didn't read the reasoning, but typically the court would provide a reasoning for which they do things, because again, they've got to support everything too by whatever rules that govern their work. So they would have provided reasoning that would explain, but in my general experience, it's not unique. They do it all the time. And if you look at the 2012, they struck out of the 6 things that Mr. Nana Akufo-Addo and the team sent, they struck out 3 right away, right? And so it's not unusual, but I think sometimes the public just follow the wind and the political talk, and then they just don't look back and they think that there's something fishy happening. But as I looked at some of the other cases, and I was gonna just quickly see whether I could see the reason, but they had a couple of reasons why they struck Mr. Akufo-Addo's petition, a lot of it. And some of it they said, some of it they also threw it away because they didn't think Mr. Bawumia was able to produce evidence to support, right? There was one case, there was a case around their electoral station code not being consistent or a fictitious one. They asked Mr. Bawumia, they said Mr. Bawumia could not really support. They also said Mr. Bawumia did not actually have a good understanding of the electoral process, because it turned out some of the electoral stations, the electoral stations or whatever that is, polling stations, were too large. So in this particular case, it sounds to me those that were too large, that they broke up, they probably assigned the same because they still belong to the same polling station. So they struck out so many of them from that particular case, right? And as I said, even those that they saw that the electoral commissioner did not do wrong, actually admitted to doing something wrong, they again still ruled against the petitioner, right? So again, I think that the judges, I would like to think that the judges know more and they have their reasoning. So I think that sometimes I find it unfair when people don't have a good understanding of what they're doing. It's almost like I'm doing my job and somebody thinks they know more on my job and they're gonna tell me how to do my job, but then my name is on it, right? Because the judges, their case, remember, people read it around the world. People study cases, okay? People cite those cases, so they know that. And so I don't think they're just necessarily going to fabricate something. And if you go over the most recent one about the witnesses, you would be amazed the detail they provided, right? They provided so many cases to support their decision. So again, it's not like maybe I'm siding with the judges, but I do think there has to be a reason for you to be chosen as a judge, right? You would have had a lot of experience, and the fact that you would act in a very reputable manner. So they struck away the other evidence. I don't know what exact evidence they struck out. I don't know the reasoning to strike out. And so in this particular case, I may not have an opinion since I do not know the actual facts. I also do not know the reasoning. But typically, if you read the ruling, especially the summary, they would have provided the reasoning. Then that's when you know whether it's sound or it's not sound. And typically, I don't know whether the other lawyers have any opportunities to appeal. But if you disagree and you think you have a reason for doing it, it is the reasoning and the facts you produce on the basis of that you can challenge. Because you can't use public opinion, just people feel or people think that it should be happening this way. I don't think they should be acting that way because, again, there's a reason why there is a constitution, and it is to protect everybody. Just so then if you accuse me tomorrow, they're not going to use it on the gravity of your stress to convict me, but they're going to use all your hate for me to exaggerate things to convict me, but they're looking at the law and the circumstances of the fact to be able to judge right? So then you're satisfied, I'm satisfied. But I think people want to use their emotional dissatisfaction or everything else they don't like to bring it into the case in order to satisfy what they would have wished outside of the forum. So I don't know, just straightforward answer, short. I don't know the specific things they struck out. I also don't know the reason. Therefore, I cannot say, but I'd like to give them the benefit of the doubt that they have a good reason. Number two, based on my reading of the recent one on electoral commissioner testifying, this is not testifying. Also read the 2013, the conclusions. What they stated, they have a good reason, and some of it was based on, again, the intentions of specific clauses, also to protect the person being sued, their right, as much as they're protecting your right? And you have to substantiate it with facts or law to be able to.
Thank you very much. I wanted to ask my last question, but I got a private message. I wish the person had posted it on Facebook anyway, but I guess it's similar to what we've just talked about so far, but I will still anyway ask. The person was asking that, I mean, a number of CSOs or civil society organizations and some experts have also argued that in the case of the EC, giving witness or not, it's also within her rights. But people feel perhaps if the judges had allowed that, they might have set some precedents, to the EC, so that in any time there is some form of election petition, the EC is expected to give witness, because there's a lot of doubts on people's minds, regarding particularly this election, and people felt that perhaps it was also an opportunity for the EC to clear some of these doubts on the minds of people. I don't know if you want to answer it, but I feel
I could answer. It's the same thing I'm gonna say.
All right, go ahead.
The same thing I'm gonna say, because when you and if you would permit me, I could just as I'm talking, I would mention exactly what they said. That makes sense, and I don't know whether that's gonna make people happy, because I also think people want the judges to make a decision to satisfy their own wish, right? And that's why people are preoccupied with the electoral commissioner testifying. I think people have their own speculation And so, so the speculations they have, they want the court to satisfy what their wish is. And that's not fair, right? That you want something else. If you want it as a citizen, once this is over, you could do a different suit and find out. But even criminals have the right not to say anything. Criminals have the right not to say anything. And I've seen situations where people are ruled or judged in absentia, right? They never showed up at the court. The court ruled in their disfavor, right? There was a case between the USA and Nicaragua. The USA started the proceedings and didn't show up at the International Court of Justice. They ruled against the USA in absentia, right? So again, people can show, and so what the court is doing, yes, the court could go against all legal rules. The court can go against general principles and Guinean laws, but in this particular case, it is their discretion also not to set that kind of precedent because they think it's a slippery slope. Because if they do that, then somebody else will cite it in the future. Then it becomes a trend. Somebody else will cite it, not just the electoral commissioner, but it may be somebody else next time. It may be you. That somebody doesn't want to testify, they can be forced. They just said it's not done anyway, that people can be forced. And my personal opinion is that I think there are different forums whereby Parliament could call the electoral commissioner to answer certain questions. I don't know for sure, but I do know that there is all kinds of mechanism within the Electoral Commissions Act whereby the electoral commissioner can still answer to some of those questions people want to know and get the answer if that's what they're seeking. But within the court, she's going to be testifying under oath, and it is also based on a litigation going on. So I want the differences to be met. Yes, people want to kill two birds with one stone, but it may have different ramifications for the electoral commissioner and as a person or as a commissioner, right? So again, I think that people can seek other firms. So instead of people getting preoccupied with the court's ruling, to me, they should seek what other avenues may be available for them to have the answer. I'm not so sure whether you care to know a summary of what the judges said about why they shouldn't, but essentially it's what I've summarized. So, but then they go specify, so they actually say specific things why they cannot. Okay.
Sure, you can go ahead and share with us.
Well, what they said, and so I title here says grounds for opposing the two respondents' intention not to testify. And here's what the court said. They said the two people, in this case, the president's representative as well as the electoral commissioner, what they said was they have both elected to adduce evidence. Initially, that's what they did. Then the court said, they essentially to adduce evidence is to agree to provide evidence to support an argument. And so that's what it means. So the court is saying previously they agreed. However, they filed and served, initially they filed and served initial statements. Besides filing an answer to the petition, and they also signed an affidavit and what have you, all those details we all know, so I won't go much into detail. But then the lawyers for the respondents, the electoral commissioner as well as the president had said, they cited a specific rule why their client shouldn't be testifying. For one, they don't think they need any more. They think they made their case. So if you also made your case, if you have any evidence to the contrary, just produce it, because don't get that evidence from them to make your case. That's their argument. Because for them, my feeling is they feel like the defense wants to get an evidence to support their case. And I think that's part of the reason they don't want to help them to solve it, because they're thinking you brought your case. So if you really think that there's something wrong, it is up to you to produce it. Once you produce the evidence, then we can defend ourselves. But we don't want to come in and give you and help you make your case. So don't rely on us. So that's one of the things they're standing on. So they cited a specific number of rules. They cited Order 36, Rule number 4, subsection 3, and it goes on. I mean, people are not interested in these numbers. So they kind of specified the laws on which their argument is based. And then they determined that the most relevant rules, so the judge also, they went back, as you see, they took about a day to look at the situation. They asked each one of them to make your case. Make your case why they should testify. You make your case why you shouldn't testify. So each one of them brought their case, and then they reviewed it, and then they convened and made their decision. So their decision, on the basis of their decision, they picked out the laws that are made most appropriate to support this case. And so they, according to the judges, Order number 38, Rule number 3E of CI 87 was the most appropriate. And so what they said was it deals specifically with the use of witness statements in civil trials. They also said filing and service, essentially filing a witness statement in this particular case was in compliance of their own order. So in other words, the defense cannot force them on the basis of the fact that they filed a witness statement. The witness statement was actually filed in compliance with the judge's orders, as we talked about interrogatory at the beginning. So the judges had ordered a specific date. Everybody should file their witnesses. So the electoral commissioner just complied with the rules of the court, which normally they are supposed to comply. So that was in compliance. This protocol, procedural, like it's part of the process. So they did it just to obey the court's orders. So that's why the electoral commissioner filed it. Okay, so that in itself, they don't think it's evidence enough to compel them because they had asked, they produced it. Now, they could have testified if they wanted to, but now they don't want to, right?
Absolutely.
Yeah, so that they also went on to say that an undisputed fact, it is an undisputed fact that the defendant in the case can elect whether or not to adduce evidence at the plaintiff's request. So it is up to the electoral commissioner in their mind whether to testify or not.
Thank you.
Okay, unless you.
Yeah, thank you very much. And I think that is clear, and I'm sure that people would appreciate the law and the position that you have shared with us. Thank you, Akosua. So maybe my final question, because you mentioned about 2 or 3 important terminologies that I think are important, and I would ask you to maybe educate the Ghanaian citizen, issues of the court of public opinion versus the court of law itself. And you also talked about people's emotions being poured out in some of these things instead of making reference to the law itself. So in your concluding remark, I would want you to touch on that and educate Ghanaians as far as exercising patience and waiting for the for the court proceedings to be over. What do you say to them with regard to a court of public opinion and also the court of law itself, and people pouring emotions out into some of these important issues? Briefly.
What I do feel is that I think as Ghana advanced their democracy, personally, I think they should start to teach people about democratic principles, including at least even teaching people basic laws, right? Especially civic law in high schools, to have people understand, because if people understand what the court is doing, they wouldn't be so upset. They would have known that they're just doing their job, right? And they would also know that even the electoral commissioner's job is governed by a specific rule, a specific process. So again, that I think Ghana has to do, because there's a disconnect. You want to practice democracy, but then only the people that go to law school are privileged to learn about law. Then the people that, meanwhile, the law affects people every day. And I think people need to understand the democratic institutions and how it works and the limitations of the agencies. Because the agencies have a mandate. They also have, so they have a specific mandate and functions. and the functions are defined, they cannot go above those functions, okay? And there is also a specific way they should do their job, that they cannot deviate from those rules. So if the ordinary person does not understand, it is hard for you to explain, because sometimes, for example, I would be making a comment and people think I'm siding with somebody, but I'm not siding with anybody. I'm just stating the fact, how I see it, right? So I think it's the lack of understanding. I also think that Ghanaians like politicization of every issue. So then every issue comes, politics comes first rather than stepping back to analyze the issue. So in terms of public opinion, I've already addressed that Ghana needs to do a bit more to educate people in civics, okay? Civics, democracy, democratic principles, democratic institutions, how they function, and their limitations and their powers. Basic law about how things work and how we should also exercise our franchise. In the previous ruling, I think that the judges made a very final comment to say there is a lot for us to do and improve the system to prevent the irregularities, because I think they were very frustrated because they do not want to be the people to take the people's votes or voting right from them because the electoral commissioner or some agents did not do their job well. They want the people to demand from their parliamentarians to help them fix the process so it doesn't come to them. That's why people make a lot of comments instead. They say elections are won at a polling station, because they said there needs to be more training for people to know their job. There has to be more awareness. So in terms of public opinion, how do we address it? I already addressed the education part of it.
True.
Well, I think people just like politics too much. And so their political affiliation governs them. And I think, I'm sorry to say, but the civil society groups are getting caught up in that. They get caught up in the emotionally charged conversations on the media because what people think. And I think it's part of it is lack of understanding, lack of awareness, that the court is not limitless in what they can do. The court does the powers that are conferred on them, and they cannot go above those powers. They have a specific mandate, they cannot go above it, they cannot deviate. So once we understand, then we can know that these areas are not addressed by the law. And so we need to petition our parliamentarians, rather than collect $20 from them to vote, we should be asking them to address that particular aspect of the loophole that allows, i.e., electoral commissioner, just in case. But for the most part though, the court has always said, our electoral process is one of the most transparent. And in fact, the European Union also said the same thing in their latest report. The only problem they thought was it's the collation center. They said the manner in which the collation is done is disorganized. So that makes it very hard for the electoral commissioner to put it together. And so I don't think it's the person, and that's what we as a people, as a society, we should be reading report for people that have nothing to benefit, right? And actually improve the system rather than always, we heard something, hearsay, we heard it on the radio and we make it as a fact. So we should look at real fact, but they really did a detailed report and said the collation, the manner in which it's collated is disorganized. And I believe that's the word they used. It is disorganized, and they said it made it extremely difficult. And so if we really truly wanted to fix the system, rather than picking one person to target, we would have been looking at the problems, what happened, the problems, and fix those problems and make it better for the sake of Ghana, rather than making it about one incident or I don't know, but that's essentially, we should be fixing the system to make it better rather than scapegoating somebody because our system is disorganized.
Thank you very much, Mrs. Akosua Jima, and thank you very much, fellow Cebsarians, those of you who followed us. We would also be sharing this on YouTube as well, and so you could later on watch the entire show. So I would like also to end just to say what Mrs. Akosua Jima said. As we go through this election petition, it's important that we do not, put our emotions into it and do not necessarily follow public opinion. It should be more of, the court of law itself. And as it has been said, perhaps for a long term, addressing some of these challenges would be to teach democratic principles across the country and also let people understand the work and limitations of various institutions. But what is important now is that let us stop the politicization of these court proceedings. Let us believe and trust in what the judges are doing. Thank you very much. Thank you very much, Mrs. Akosua-Jime again. Thank you very much, Albert Kobna-Mensah, who helped produce the show. I am Evans Apia Kisi. Hopefully next week we'll bring you another interesting discussion. Bye-bye.
Thank you as well. And I would like to add that we should also take our time to at least even read the judgments to educate ourselves so we know the reasoning to understand what is happening. Thank you too. And thank you, listeners.
Thank you. Thank you very much. Bye-bye.